Hi there, I'm Jenna Leyton Jones, the Vice President of Legislation for San Diego SHRM, and today I'm bringing you your quarterly employment law update. Let's start by taking a look at some pending California legislation. The California legislature is considering a number of bills which, if enacted, would impact California's employers and employees. One of these bills is Assembly Bill 1522, the Healthy Workplaces, Healthy Families Act of 2014, which would provide that an employee who works in California for 7 or more days in a calendar year is entitled to be paid sick days to be accrued at a rate of no less than 1 hour for every 30 hours worked. An employee would be entitled to use accrued sick days beginning on the 90th calendar day of employment. The bill would authorize an employer to limit an employee's use of paid sick days to 24 hours or 3 days in each calendar year. In addition, AB 1522 would require an employer to provide sick days upon the request of the employee for diagnosis, care, or treatment of health conditions of the employee or an employee's family member, or for leave related to domestic violence, assault, or stalking. AB 1522 would prohibit an employer from discriminating or retaliating against an employee who requests paid sick days. The bill would also require employers to satisfy specified posting, notice, and record-keeping requirements. The bill has been referred to the Assembly Labor and Employment Committee. The legislature is also considering AB 2095, which seeks to amend Labor Code Section 226 by limiting frivolous litigation regarding itemized wage statements for alleged technical violations. If signed into law, AB 2095 would permit an employer to recover attorney's fees in actions where the employee was not injured and the litigation was brought in bad faith. AB 2095 has been referred to the Assembly Labor and Employment Committee as well as the Judiciary Committee. In addition to the bills I just mentioned, California's Department of Fair Employment and Housing recently published proposed amendments to the California Family Rights Act, or CFRA. These regulations are intended to clarify some aspects of the existing regulations and also to adopt many of the recent amendments to the Federal Family and Medical Leave Act, or FMLA, regulations. The proposed amended regulations address, among other topics, number 1, the length of service and eligibility issues, number 2, the certification process and timeframes for responding to employer requests for CFRA leave, number 3, computation of the amount of leave entitlement, number 4, key employee issues. Number 5, clarification of reinstatement rights. Number 6, maintenance of health and other benefits during leave. Number 7, retroactive designation of leave. And number 8, the interplay between CFRA leave and California's pregnancy disability leave. Importantly, there remain some areas where CFRA administration will continue to differ from FMLA administration. Among other things, pregnancy disability is not covered under CFRA, and therefore a California employee who is otherwise eligible for leave under CFRA or the FMLA will be eligible for up to 4 months of leave for pregnancy disability under the Pregnancy Disability Leave Law, and up to 12 additional weeks of leave for baby bonding under CFRA. The proposed regulations state that a California employer is required to maintain the employee's group health benefits for this whole period and not just up to 12 weeks. Some other notable differences between the CFRA and FMLA are that the medical certification and scope of permissible medical inquiry are much more refined under California law than under FMLA, and the circumstances under which an employer can seek recertification are narrower under California law. There is a public comment period through June 2, 2014. Comments can be submitted via email to fehcouncil@dfeh.ca.gov. Now let's switch gears and take a look at some of the recent judicial decisions that may affect your business. In Taylor v. Nabbers Drilling USA, a California Court of Appeal confirmed that sexual harassment need not be motivated by sexual desire. Plaintiff Max Taylor filed a complaint against his former employer, Nabber Drilling USA, LP, alleging a series of violations of the Fair Employment and Housing Act. Among other things, Taylor alleged that during his employment, he he was repeatedly harassed as a result of his perceived sexual orientation. At trial, Taylor presented evidence that he was the victim of a series of vulgar, offensive acts and statements by his coworkers. The jury ruled in Taylor's favor on his sexual harassment claim. In response, Nabbers requested that the trial court reverse the verdict based in part on the fact that the evidence presented to the jury was insufficient to show that Taylor was harassed because of his sex and/or sexual orientation. The trial court denied the request, and the appellate court affirmed the ruling. The appellate court, noting recent statutory and case law establishing that sexual desire need not be present in order for a plaintiff to succeed on a sexual harassment claim, was unmoved by Nabbers' argument that the harassing acts were merely his coworkers' means of making fun of him. This case serves as an important reminder that the definition of sexual harassment under California law is broad. Employer policies should reflect this fact, and employees should be trained accordingly. In Mendoza v. Western Medical Center, a California appellate court held that a common law wrongful termination claim must be analyzed pursuant to the substantial motivating factor standard as set forth last year in Harris v. City of Santa Monica. Plaintiff Romeo Mendoza was employed as a nurse at Western Medical Center. In October 2010, after 20 years of excellent performance, Mendoza reported to management that his supervisor had been sexually harassing him since August 2010. Both Mendoza and his supervisor are gay, and Mendoza claimed that the supervisor had repeatedly subjected him to explicit sexual comments, unwarranted touching, and lewd gestures. Western Medical investigation of Mendoza's complaint was limited to a simultaneous interview of Mendoza and his supervisor by a manager without human resources expertise. The supervisor claimed that Mendoza initiated the inappropriate activities and that he had only reluctantly engaged in the conduct. Western Medical did not interview any additional witnesses. Based on its investigation, Western Medical fired both Mendoza and the supervisor on the ground that they had engaged in consensual but inappropriate and unprofessional conduct. Among other things, Mendoza sued Western Medical for wrongful termination in violation of public policy. Mendoza claimed that Western Medical's investigation was woefully inadequate and that his discharge was merely Western Medical's attempt to rid itself of everyone involved in the incident, regardless of culpability. Mendoza alleged that he had done nothing wrong and that his discharge was based purely on his harassment complaint. At trial, the jury was instructed to find for Mendoza if it found that his report of sexual harassment was the motivating factor in the decision to discharge him. However, in response to a request for clarification by the jury, the trial judge advised the jury that it should find for Mendoza if the sexual harassment report was a motivating factor. The jury found in favor of Mendoza. Western Medical appealed, arguing that although the original jury instruction was correct, the judge's explanation of the instruction was incorrect and thus amounted to prejudicial error. The appellate court ruled that the judge's instruction was improper in light of the California Supreme Court's 2013 ruling in Harris v. City of Santa Monica, wherein the court held that the proper analysis of a Fair Employment and Housing Act claim is whether discrimination was a, quote, substantial motivating factor, not merely a motivating factor. The appellate court in the instant case held that since Mendoza's common law wrongful termination claim arose through an alleged violation of the Fair Employment and Housing Act, logic dictated that the causation analysis should be the same. Accordingly, the appellate court remanded the case to the trial court for a rehearing of the facts under the proper standard. Notably, the appellate court was critical of Western Medical's handling of Mendoza's complaint. Rebuking Western Medical's response, the court noted that employers should conduct a thorough investigation and make a good faith decision based on the results of the investigation. Hopefully, this opinion will disabuse employers of the notion that liability or a jury trial can be avoided by simply firing every employee involved in the dispute. Mendoza is a reminder that employers should perform in-depth and meaningful investigations of employee complaints, as investigative findings not only constitute the grounds for employment decisions, but are also the foundation for defending those decisions at trial. The cases I just mentioned are just a sampling of recent judicial decisions that affect California's employers. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshrm.org. Additionally, I invite all of you to join San Diego SHRM's legislation committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please email me at jleyton, that's JLEYTON, @petitcone.com. That's all for this quarter's legal update. Thanks for tuning in.